Yes.
One and not this. One and two, both the process. Item
1 and 2 means?
item number one and item number two.
Okay. They want to not press. Okay. Not press.
Item number 3. Item number 3, sir.
Yeah, please, in this review petition, I had raised essentially 2 points. One was that the contract in question, being a works contract, does not come within the purview of MSME. The second point was that the second point that I was making was that it is imperative that the purchase that the seller intimates to the buyer of his status as a MSME unit. If that is not communicated, then he cannot claim the benefit.
What is the error apparent on the face of the record?
Yes, Madam.
Sir, there may be some erroneous finding, but that does not mean that the review is proper.
In fact, your lordship had raised this issue on the question of maintaining.
Only thing is that some findings, something which is absolutely contrary to record.
I will show that to your lordship. I am absolutely conscious of that.
Yes.
And since your lordship had raised the question of maintainability, I will address your lordship on that first.
Correct.
For that, my lords, I will firstly take your lordship's own judgment, delivered in Calcutta High Court.
Oh, putting me on let me see. Oh,
Paragraph 4, my lords. Paragraph
that is in relate to a DA matter.
Yes, absolutely. But the principles on which a review would can be maintained. At the very threat.
Have you not brought the subsequent judgment to this on a review? Sitting with Justice Samanto.
Yes,
that is also in relation to a DA matter.
That seat, but I have not carried that judgment. What I've carried with me, my lords, is the judgment of the Supreme Court, which I have.
Same parties, don't worry. There is a two review judgment.
Yes,
same party.
Yes, here there is one judgment of the Supreme Court where this principle has been.
The main principle is decided in Tungabhadra's judgment. That is a AIR 1967 or 68 Supreme Court.
That has been further illustrated in Board of Cricket.
That is what Justice S.B. Sinha's judgment.
Yes, so this is Justice Sinha. So if your lordship takes paragraph 88
88 says ILR, there was one judgment from ILR is quoted that on a subsequent event, the review can also.
Absolutely. And that is the point that I'm trying.
ILR judgment is quoted there.
Yes. And that is the point here which I've
that has also been dealt with by me sitting in a division bench with Justice Shubhra Kamal Mukherjee, and how I have dealt with those judgments.
Yes, madam. And that is exactly the point that I'm trying to make here, that there has been a subsequent.
In BCCI, the matter, that is the Netaji Sporting Club versus BCCI.
Yes,
if I correctly remember.
Yes, madam. Netaji Cricket Club.
Yes, that's it. I thought a sporting club, any cricket club. So what was the scenario there? The scenario was that the order was passed on a perception from the council appearing for the BCCI that this is what the state of affairs are. Subsequently, it appears that there was a meeting which was held and the decision was taken something diametrically opposite to that. So the review was filed, bringing those facts that this was the error, because the record would reveal that something else was there, but it was perceived as something else.
Absolutely.
Then the Supreme Court says that since this decision was taken subsequent to the order, and a conscious decision appears to be not in tune with what the stand was taken before us, then there is no fetter on the part of the court to review its judgment on such score.
Correct. Correct.
But that was only the special facts of the case.
One of the special facts of this case are borne out from Annexure 1 and 2. If your Lordship will kindly see document annexed to as my review application, which is a subsequent event. This the law was there. It was explained by way of this notification. Okay, Annexure 1.
Right.
Oh, good. Review petition. Yes, madam. Your Lordship may take the IA number 351 of 25, page 20, page 15, madams. Flag A. This is notification of the government of Orissa of 2024, January 2024, after the writ appeal was, writ petition is of 21, this is 24, they clarify that what the state cabinet approves is at serial number 4, they say the policy will, however, not be applicable to procurement of services, including works contract. This is a contract which is for procurement of services. It's an out and out works contract. It would be impossible to segregate the part of supply and the part of execution.
That is why I give its Second Amendment of the Constitution, the work contract concept has been imbibed into the
And that's the
Constitution.
point that, my lord, this was a point taken in the writ petition. It was not considered by the court. And my lords, the point here is that
then in
since
that
this,
event, go there, go to the High Court, get it done.
no, but this is something that was before, this notification was not before the court. And in the meantime, my lords,
Notifications that did not see the light of the day on the date when the matter was disposed of.
absolutely, but what
It
the
sees its
notification says,
birth after the same.
but the notification does not
The
propound a new
difficulty, I
law.
tell you, Mr. Mukherjee, what I feel is that if the review jurisdiction is expanded to such a horizon, then there will not be any finality to our litigations. The difficulty, suppose a proposition of law is laid down in a particular judgment, and later on it is found that that proposition is not accepted, and the just or the opposite proposition of law is taken. Does it invite a review application to be filed before the court, saying that now look,
No,
this proposition
what
is
was before the court was that it was a works contract. It does not come within the purview of the MSME. Now, this was not something that it was not backed by the notifications, which are clarificatory in nature. It's not the notifications do not propound a new law. They
no.
basically
It simply says
clarify
that the work contract
is excluded.
is excluded.
Is excluded.
That's a
Now,
understand.
this has again been reiterated by the state government in 2025. And now, my lords, what has further happened is there is a judgment of this honorable court by a single judge, of course, which also says that works contract cannot come within the purview.
Please bring that judgment, because you are talking about the judgment.
Yes. Yes.
My judgment there with Justice Shubhra Kamal Mukherjee.
I'll get that.
Please get it. I think I have dealt with this exactly this proposition, and then you'll have to convince me that I'm wrong. I'm still open. If I have committed wrong, I am bold enough to accept that I have committed wrong. But you'll have to bring that judgment.
I will, my lord.
Bring that.
But before that,
Party's name I do not remember,
I will get that judgment. In fact,
which I used to be when I was on that side. At least one name.
Well, there's just one judgment which our own High Court, where this honorable court at page 5, I have just passed on that judgment. If your lordship sees,
What it says.
it says one of the grounds which the court has addressed is whether the present contract is a works contract, and if so, could the MSAFC have entertained a claim arising out of the works contract?
This is what are the factual metrics.
No, not whether it's a works contract. If it is a works contract, I'm saying.
Suppose a court has held that it is a work contract.
Yes, madam.
It is included. that makes the judgment as erroneous.
No, Manoj. What, here, there are two parts to it. The court examined whether that was a works contract. And the second part which the court examined was whether works contract can come within the purview of MSME.
MSME.
I am on the second part. I'm not on the first part.
True. I am asking you. I'm just saying, suppose the court held that it does not come within the purview of MSME, or held that it is within the purview of MSME.
A works
Now,
contract does
these-
not come within the purview of.
I'm asking, I'm telling, in both the situations.
Yes.
The court may either held that it comes within the purview, may also held it does not come within the purview. Let us take it. And it appears subsequently that no, this finding is not correct. It makes the judgment erroneous. Can it be termed to be a error apparent on the face of the record or a patent error?
Well, if it is, it is
Perhaps,
not.
You can correct it by going higher up and saying that this judgment is not a correct one.
Manoj, the point that I was trying to make was this, Manoj. Here we have a specific case that it's a works contract. It falls within the.
And the court has said that it is not.
No.
Sorry, let us go. Court held yes, but it comes within a MSME.
No, then it's a question of fact. The court holds that it is not a works contract, then it becomes a question of fact.
No. Even if suppose a converse situation, the court holds it is a work contract
Yes, Manoj.
and then says comes within the purview of MSME, which according to you should not be there because it is outside the purview of MSME.
Then it's a apparent on the face of the law.
Now, that's the big question.
Yes.
Is it an error apparent on
Yes,
the
ma'am.
face of the record, or is
Because the
it
law
an
says-
erroneous finding?
No, it's
Is the
not
erroneous finding?
When the law says that MSME does not come within the purview of MSME,
No,
and the
on
court
that
says otherwise.
Question is on that day, that particular decision of the government was not there.
What was
It
there?
was consciously taken subsequent thereto.
No. What was?
Never argued. It is only supply of material which was argued.
Was there is section 2,
Mr. Dutt,
subsection 119 of the CGST Act. which says-
Mr. Dutt, perhaps in this line there was no argument advanced. It was only supply of material and your registration after the award is passed.
I'm deeply believe.
And that was the crux you argued,
That is-
as I remember.
Yes, ma'am.
I don't remember. I just remember faintly.
Single judge has rendered
So
the
never-
judgment against me.
Whether works contract or not
Never.
comes within the fold of
Never
MSME
been
Act or
argued, never
not.
been raised
That was
anywhere.
never raised, never argued. Perhaps
That's
I'm
why
correct
when senior
to
is
say-
wrongly informed.
because I was one of the members there. So I'm just telling that
And then the
the
repetition is there.
part which has never been argued, can we in review jurisdiction in a long run process of argument again entertain this?
Has never been raised in the rate application at the first place. Never been raised
Only
before the
only
MSME.
question was whether your registration which was taken subsequent to award being passed
Exactly, madam,
and
that's
supply was made
only.
and you will come within fold of MSME or not.
Well, your Lordship, may at this juncture, kindly see paragraph 4 of your Lordship judgment in written. Page 28. Well, what has been recorded by your Lordships is this, Madam. The facts which are not in dispute are that the respondent number 1 had awarded the appellant a work of fabrication, erection, painting, etc., structural steel work in connection with power so and so. Various amendments to the original work were made, and the last amendment was made on so and so door. My lords, on the face, just a minute, on the face of it, this squarely falls within the definition of section 2. Subsection
That was never raised, sir.
CGST Act.
That was never raised. It is only supply of material which was questioned there. And the registration only was harped at.
They are the petitioner before the single judge.
Registration which came into force, his registration was granted after award being passed.
The law is, definitely find out the judgment of my lord, the Chief Justice of the Calcutta High Court. If there is a new fact which comes to light, that is a ground on which I can raise a review, and that is exactly the ground that I'm trying to raise, Your Honor.
On the Supreme Court.
It has come to light by way of the clarification of the state government and the judgment of this honorable court. Along with that. So, my lords, on the basis of these new facts, I would like to raise this issue in the review application. Your Lordship, I'll come back with that judgment of Your Lordship.
On the outstreams of mine. Under Annex 2 also, we had got.
Why you want a refund of the money?
Minor.
Why?
Your Lordship kindly see page 15, that is the net legible copy of page 15 I filed. There, my lord, one person, Krishna Chandra Nayak, my lord, made a grievance against the petitioner. That was, my lord, investigated by the Inspector Excise. In second paragraph, your Lordship kindly read. I checked the challenge of the shop, considering money for 4 months, April, May, June, July 24, in advance has been deposited. License issued on dated 29/1/2024. It is stated functioning after getting the license. Prior to that, after the sale hour dated 31/3/2024, the shop was closed under siege. The shop had 3 branches of.
No, it says that there is no
Well,
violation of the license
well, there's
conditions.
no-
By-
My lord, sir,
Understood. Then,
there is no, my lord, your lordship, I have not committed any mistake. But the shop was closed as because one person, my lord, made allegation against me.
whatever, then,
My lord. Since, my lord, I have deposited the amount and the shop was closed from 31/3/2024.
what amount? What
I have-
amount?
My lord,
What amount?
I have deposited the money.
50,000.
My lord,
For what? Under what heading? For what? Under what category you have
my lord,
deposited?
I have
Security or to show your bona fide?
My lord,
What?
That is the annual fee, that is page 13, your lordship kindly see. The eligible copy I have filed, my lord.
Page?
Page 30,
Yes.
1/3. That is
Yes.
the non-refundable, there is, I have no, but the second. Annual fee for grant of license, next licensing year, my lord. That is I have deposited. So they have to calculate and, my lord, whatever the amount, my lord, they have to adjust. I have filed one representation to the authority, but they have also not considered the same as per Annex of.
What is this? How can you withhold it when the shop is not functional? You have put a seal. Then why?
Also, I'll apply instructions on this one.
Second week.
Item 6.
What's in this case, I have been directed to obtain instructions, but I've received some instructions which that they are inadequate. Let's say pray for one more opportunity, a short date may be given. Next week,
29th.
No,
Item number 7.
On to player.
I am taking the option. Your Lordship, copy number 7 was filed in counter affidavit. I have received the copy right now. You want to file the rejoinder affidavit? Which time?
it is not come on record, but I'm filing the hard copies. We have filed the counter affidavit on 8th.
Therefore,
Copy number 7 will is filed. But on behalf of all the opposite parties.
All the.
All the opposite parties. Opposite parties, state opposite parties.
for rejoinder, it is reiterate and restate, nothing more than that.
Which,
Re- Just 3 weeks. If you want 3 weeks, 3 weeks.
Mr. Smith also instituted. It is on presentation. You filed again.
Next.
Item number 8.
okay. Fiction has been lessee of the sand of manner.
What?
Lessee of the sand manner.
Oh.
He could not lift the sand as per the allotment manner.
There was no sand.
There is no sand manner. For that reason.
So why you have taken a sand surveyor? Please.
Thereafter, I have stated before the authority to adjust the royalty amount for that year, for the next year manner. That has not been done manner.
Next year you will get the sand.
No, there is less sand manner. The quantity which has been fixed, the.
So have you lifted the full one?
No.
So,
So the quantity is much less than the allotment.
so that's your fault.
It is my fault manner, but
So there was a
What that is, I
plenty
have
of
said
sand.
that-
There was a plenty of sand, but you could not lift the.
no, there is no sand manner. Your lordship, see the report.
Earlier, some other person or you
No,
were,
I am.
Ah.
No, 22 रू.
you are not,
मैं 21 रुपए 21 रुपए from 21 onwards I
21 you got.
22 रू
Prior to that, some other
other
person,
persons.
you were not.
No. Your lordship, the report says that there is a less quantity of sand.
He was continuing.
Yes.
You got it.
22, 23 days, but actually 22, 23 days requires money.
So you wanted an adjustment or refund of the money.
Adjustment of the amount.
But
Is there any provision for adjustment?
there is no provision
No
for
provision,
adjustment,
sir.
but if your lordship may kindly see annexure 6,
Yes.
there is some Odisha public demand recovery from him. One proceeding is pending. That is what the Tahsildar has intimated to the mining officer. So I'll have to take instruction on this.
That
Annexure
is with
6.
respect to year 2022.
One.
This is relating to the last.
How
year,
much
sir.
money?
Alert,
The certificate officer
Yes.
must have issued.
Around
But
20,
that money has
around
been,
20,000,
but that is
26
26 lakh 87,810.
26 lakhs.
Yes.
Okay. And how, what is the amount which he wanted to adjust? What is the amount, sir?
Amount I have taken instruction, but the quantity is 18,606 square feet. Square
Must
meter of
be
land.
commensurate with that amount.
I have to take instruction.
So in a certificate proceeding, he stood as a garnishee. So
But I
now,
have asked for the
now
certificate,
he will be
certificate,
bound.
But that is a proceeding
If
related
that
to this.
proceeding is pending still, they cannot
this
adjust
card,
it.
this card with 26, I think, 2,60,000. Because almost 20,000 you see.
But that amount has been
20,000.
mentioned.
13,
Annexure 6, that amount has been mentioned, madam.
Like 26 lakh.
Unrealized OPDR amount, rupees 26 lakhs 87,800.
Hmm.
And that proceeding is pending, as it appears from Annexure 6, because this was issued.
So how can it be done?
And thereafter they have
Thereafter
allowed me
means-
to operate
No, they will definitely operate, so allow you to operate because they
I have
cannot,
asked,
they
this
cannot suffer the loss of exchequer.
No, my lord,
But certificate proceeding is there against you.
certificate sitting from last year, my lord, I have asked them what is what is this amount? They have stated that we have given a letter to adjust the amount for this year. They have not done, that is the OPDR amount they are saying. My learned friend must take instruction, if it is not for that year, my lord, then I have no case. My lord.
Let me take instruction.
Second week.
Item number 9.
May I please? And follow letter 24th of September, you were directed the non-state council to take the instruction, which is relating to the reconstitution of the trust board of
Drug board.
trust board of the district mineral foundation. The rule provides from out of the local representative of the affected area, the people should be taken into taken as member of the trust board. The relevant portion I have quoted and I am having the rules. So let's may kindly have a glance to
This
the.
matter, my lord, we are filing affidavit today, my lord. I am sorting a copy to my lord senior. Everything is fine.
Everything is clarified there.
Are they belongs to that area or not?
That is it today. They are filing today.
But apparently I have mentioned.
They must have.
I am listening.
We are recording. In the order itself, we are recording that you have served a copy of the counter affidavit to him. No more.
Like technically what happens when we are making the e-filing, if there is no endorsement, they are not happy.
We will record in the order.
I have
Is record with that.
Yes. So, the particular that's so one.
bulkiness of the counter needs a result.
Why? You are also very experienced, our minds, also there is also there.
At times it is not required.
More the repetitions of the opposition, less the legal it contains.
My learned friend said, indirectly gave the answer that they do not belong to that particular area, but it has been interpreted.
You did not, you
Yes,
did not
I
understand.
could follow
what I
you.
said.
Yes, short.
Minor. Just to say that the more bulky the petition is, the point of law will be.
Right. Right.
That's my experience over there.
That's right. Short gate may be fixed because the persons who not belong to that
29th.
particular area.
29th October. Item number 10.
Also, the tender call notice under Annex
Why you are withholding?
That's, the position what he is contending is, as for me, is correct, my lord. Just like instruction with respect to Annexure 6, what steps have been taken, my lord, because it has already been intimated to chief engineer for. Yes, my lord.
Is a substantial one.
Yes, my lord.
What do you want?
Only instruction with respect to Annexure 6, my lords.
Well,
2 weeks, my lord.
Madam.
He is apparently review.
Item 11.
I have some personal difficulties. Mr. Nag has some personal difficulties. So I'll get out for
Item 12. Item number 12.
Mr. Firoz. Mr. Firoz. Firoz. Asperity does not appear in it.
12. Madam. Item 12. Madam. Still take case of.
Okay. If we just ask Mr. Hansara, he must have missed the list.
Item 12.
Item 12. Kindly
Last occasion, Mr.
kindly note it and intimate it.
Okay.
You are simply directed to disclose whether any decision is taken by the competent authority.
This decision is not taken, sir,
Is there?
because I have received instruction in this matter.
Then
You have not.
And use the word misbehavior. The part.
There is some factual aspect.
So
This
why
is-
you know?
This is relating to payment of escalation price. What
There
happened,
were- If
when
there
the
is
child
there is a
execution-
clause for escalation, then you have to take a decision.
There is some factual aspect. I am clarifying, when that time extension was granted, first of all, he filed a no objection certificate that he will not claim escalation. And secondly, the escalation clause which is incorporated in the contract, by virtue of a government notification that is passed by this honorable court in a contractor association case, we need to file an affidavit to that.
Yes. 2 weeks.
Sometimes it's order dated 23.
No, he says that we have no decision in the. So, but we go to this.
We have said affidavit to size.
Right.
Yes.
Item
What we rejoined.
Item number 13.
Lastly, when Mr. Das was trying to obtain instruction of release.
Well, item 13 only I pray may be taken up on Friday, because the instruction that has been prepared by the DDS mines, they have sought for the verification from the director of mines. Only I pray let it be taken up on Friday so that I can produce the instruction before the honor.
Item 14.
Presidents tomorrow.
17.
Yeah.
Make resolution. The collector and commissioner has recommended for grant of license. The government is sitting over the matter for last 6 months. They are not passing order. You have to, there are
Why?
3 recommendations from the collector and 1 from the commissioner itself.
What is instruction that you have? But after tomorrow cannot take instructions when it's considered or not considered or they are under consideration.
Good.
After
Some cases are really for consecutive few some are very common.
page 28. The Commissioner,
On 30th June.
Commissioner has recommended. Annexure 8
Yes. Yes.
instructions with respect. Annexure 8.
Yes.
Sealing of that excise of the Rothschild passed a legal order made for yesterday.
The sub-inspector of excise having no authority has sealed the shop because seizure was from one Rajkishore Pradhan. Based on a co statement, SI has sealed the shop without any authority. Last one.
Oh, we have declared yesterday, I believe.
Yes, please.
This is the day before yesterday. Where is the dictation? We have decided it or no?
No. This is not, it was taken up day before yesterday.
Okay.
The issue was to seal closure of the shop by sub-inspector of excise.
This matter? Or in other matter?
No, this is the matter, not 27606 of 20.
This is same matter. The order sheet is not clear, that's why.
Order has not been uploaded.
Yes, what you say, this is a pure question of law.
That's my instructions to the officer are that there is no other provision, no provision is there in the statute or the rules for closure of the shop. The only provision will not this.
Closure of the shop is there. But
It is there.
has to be exercised by some other authority.
Yes, Miller.
Strict or sub-division.
Section 26.
26.
Section
Well,
26.
46, section 46 or 46 talks about suspension.
47
47.
it's about suspension cancellation.
So, Section 26 provides for closure of the shop by the
By some other
By the
authority
district
and
magistrate.
under some specified circumstances.
in public for public peace. For if there is an apprehension of breach of peace or in the interest of to avoid a law and order situation, that has been provided to the district magistrate under Section 26.
Can he do it?
No, my lord. There is no other provision apart from that particular
So,
Section
how can
26.
he see this?
My lord, they are doing it by dint of this circular I had given on the last occasion also.
What? That's it.
No, they are just seeing it.
My lords have seen on the last occasion. My lords wanted to know whether the statute provides, but the statute doesn't.
It's
So it
completely
is only
power and power beyond the district magistrate and commissioner of excise also. When it is limited for district magistrate for 3 days, the power given by a circular overriding the statute, overriding the rules, much beyond that limit. Unfettered power.
You are in the department. Whether there is any rank attached to it. Rank is only a rank.
Yes.
But they are officers.
They are the officers, that's the.
Sir, Lord, can you arm us with a certain judgment? It says that if the power is not provided in the statute or in the rules, the administrative authority or the executive cannot issue any kind of a notification or a circular.
Yes, circular cannot override the rules. Or
No,
statute.
not overriding, which is not contemplated in the act.
Right, tomorrow I will.
There are two aspects. If it is contrary to the provision of the substantive act or a subordinate legislation, no doubt, it's a very open and shut case, not a problem. Right? Gone. But if there is nothing which is provided in the statute, substantive and the rules, but by virtue of an executive exercise of powers, something is contemplated, then in that event, how far the court should interfere
Right,
into such aspects? These are the questions one has to decide.
yes, not either tomorrow or Friday or Monday. I think.
You check up
And then what is
hidden criminal case in respect of taxation act next central estates. Their power is conferred under the statute to the commissioner to issue circular.
No, that is under
So
the
that is,
customs excise and these are the powers are their notifications as a statutory backing. In those, because Act provides for issuance of the notifications or the circulars. It is, they are within the past, and you will find the series of judgments of the Supreme Court where the notifications have been given a recognition as a statutory piece of evidence. So there is no doubt in that regard. In this, I do not think there is any provision which has been given under the Excise Act. Though notifications comes, but to what extent the notification would come? Because what I find is that in this notification, Section 26(1) empowers the district magistrate to do it closer. That to a period of 3 days. If that is what that is to be extended, then the excise commissioner is to approve it, and then he, on his instruction, it can continue. So the role of the excise commissioner really comes, but that comes after the closure is done by the district.
Yes.
Section 26 also talks about the situations in which the closure can be done.
Right.
Something which is beyond the purview of this eventualities or the contingencies which is provided in this Section 26. Whether this authority is by virtue of this circulars or the letters can fill up the vacuum which is apparently there, and to what extent? Does it go counter to the spirit of the legislative mandate?
Yes.
Or
Yes.
complementing each other?
Or it can supplant. Either.
Supplanting has a problem. Supplementing I can understand.
Yes.
Supplant is a big issue
Yes. That's
that they cannot.
They can.
Supplanting is not permissible. Supplementing or complementing is to what extent it is permissible.
Yes. Suppose something is there, basis is there, you are magnifying it or you are extending it. That I can understand. But when there is absolutely no basis with this authority, superintendent or sub-inspector of excise, having no power at all in the act or rules.
Because that's a very fundamental principle which we in administrative jurisprudence is that an individual can do anything unless forbidden by law. An individual can do anything unless forbidden by law. A statutory authority cannot do anything unless permitted by law. Yes. Yes, that's a very golden fundamental principles of administrative jurisprudence.
Yes. I'll come back on Monday. I'll assist.
So that is what I was
Yes.
I was thinking about.
I request my learned friend to sort me a copy of that, sir.
Yes.
Kindly see one. Kindly see.
Not that so easy. What he says is that something which is not there in section 26(1).
Yes.
We find that still the closure is required. Can be not taken.
The 26(1), let me be very clear about that. For maintenance of public peace, there is no concept of an investigation. People are kindly let us see again 26(1). There is no concept of an investigation.
And that's why the authorities say that this is what the scenario is. Then in that case, what to do? So they have issued this particular circular or whatever, letter. Saying that
Not even a
situations, it can be exercised.
Lord, this your lordship kindly see, the Joint Excise Commissioner has no authority to issue such a letter.
I just, that is what is getting at the root.
Yes.
Who can issue?
Government only can issue.
I do not know under the law.
That's on section 90.
That's true.
That is only under section 90 of Excise Act.
That is what, then we'll have to go into that aspect.
Yes, section 90 only empowers the government to issue circulars and orders in the interest of excise or whatever.
What I'm thinking is also that once a power for closure is provided to a particular authority consciously by the legislatures, that means that impliedly they take away the authority or the powers of other authorities to do the same.
Some delegation of power. Delegation of power.
That's what is a.
Unless it is permitted, AR 55 Supreme Court page 158. So delegation of authority, unless it is permitted, you are not allowed to do.
That is on a different note.
Yes.
That's on a different note. I'm on a legislative or a jurisprudential point of view.
Yes.
I'm just thinking. That is generally a specialist supplanto or something that the maxim is. That maxim comes. It says that if something is consciously omitted.
Achha. Omissus casual.
No, gaseous omissus is different. They're different notion. What it says is when there is a completely, I think the omission in the statute, then in that event, the power which is given to a particular authority has to be construed in such way that it takes away the powers of the other authority to exercise the same. Like this example is where if it is given to a district minister, then in that event, the other authorities cannot assume or usurp the
Observe the power and exercise. Achha.
Cannot. And the legislature has consciously excluded them from that power.
Yes. I could get the point.
Supplant or something very illegal.
I like. No, Nazir Ahmad Babu Bhagi
No, Nazir Ahmad is that something is required to be done in a particular
manner.
manner. I think 36 Privy Council.
The 36 Privy Council, then 99 Supreme Court Babu Bhagi versus
Varghese
versus
is the-
Kerala State
that what is there.
I could understand, Lord. Your Lordship is trying to know assist your Lordship, that if the power is conferred to the district magistrate, any other authority other than district magistrate,
It necessarily
Outstate.
excludes the power
Outstate
of
from-
the powers
right
of
to
the
that.
other authorities first.
come back. I'll come back.
On a legal principles, on a maxim.
Yes, I'll come back. Yes, means legislature in its wisdom intends to exercise the power through that authority only. Right.
Next step.
Yes.
Friday. Right,
Which
Friday or the,
Friday?
Your Lordship, please.
30th,
Friday.
right? This Friday.
Also, board will be heavy on Friday.
Yes.
Maybe 22nd. Any day next week or the
30th.
In
30th.
that case, may I just request for an interim order because the shop is like closed. I'm sided with it. But this can be opened subject to that supervision. There is absolutely CCTV is there and your Lordship in Barampur case. In Barampur case. Yes, gave some relief to that case. Let them open
What he says is correct, sir. This.
Let that be decided, my lord. My lord may take some early date also, but once the shop is allowed to be open, my lord, everything will become topsy-turvy, my lord. There, all the stocks will be.
He is more conscious about Bhashani. Let him Bhashani go.
Tangi, it's not in the vicinity of Pataka Bhubaneswar. It's a rural area.
No,
My lord,
Kali Puja.
Hmm?
They will do Kali Puja.
Kalipuram, but Tangi, it's a rural area. It's not. small Gram Panchayat headquarters. No such urgency will be there. Only thing is that I am saddled with license fee MGQ.
They are exposed to this.
I'll tell you lot. It is only
Be a Gram Panchayat, but they are very much exposed to.
why this is done, Milord, the competitor will be benefited. That is all. All thing is behind. Another competitor is behind this. The other man will be benefited.
A person was arrested while he was transporting liquor illegally.
That
person has
somebody now again I'm saying. Can a statement of a boy.
No, one can.
No.
No, cannot Milan.
Unless you establish a chain or you establish a link.
And what is
No,
the
then- Then it will be I would say the chaotic situations that would come in the society if this kind of things continue.
my friend will appreciate it.
Not, yesterday also we pointed it out that if you were so conscious while going there and sealing the shop, did you not check the register, the stock register? Did you not check the stocks which was there? If there is a disparity, I can understand that there is some kind of a linkage which is established. If there is nothing on that line, how can you mere on such will you?
And what is the allegation? 2.5 permissible, I have sold 12 liters. That's all.
All that I understand.
That's the issue. You can settle a fine on me 50,000.
You can sell it to 10 persons and 10 persons can jointly sell it to one.
That is what the point is. Management should appreciate this. Why to close it at their own cost of revenue?
These facts are absolutely.
If the shop is allowed.
No, sir, this is something I feel is absolutely correct. It's sound on the principle of law.
But my lords may also appreciate Milord. Once that person, a case has been opened, Milord. An investigation is ongoing. On the basis of this statement,
Sir, what is the difference? Is he selling a spurious liquor?
No.
No, Milord, that is not it.
No.
No.
Is he selling without any the record being maintained? Till now, no.
That could be the case, Milord, but that investigation will
What are
say.
you talking about? You have not come up with the, I would say, slightest of evidence as of now against him. Your only grievance is that he is permitted to sell 2.5 liters of a liquor to an individual and not beyond it. Your contention is that he has sold 12.5 liters to one person, which is
Beyond the license terms.
beyond the permissible limit. If that is the only allegations, then in that event, I don't think so. And your power to close the shop is also, sir, very, very, very doubtful.
Well, it's
Very doubtful, sir. Give me that excitement.
Simple reason, Milord, why it has the only reason, Milord, why it has been closed is that circular, Milord, which I ran. That is the only and the sole reason. Lords are correct in saying that, Milord, that there is no other allegation, but that circular stands in the way, Milord, of the officer, Milord, so far as the officer is concerned.
The point of law as Adam, as I understood what you want, that you will approach the district magistrate and
No, not at
and
all. Milord,
convince
not at all,
him
Milord.
that what
No,
to do and what not.
If there is a, if there is a blanket order in view of the
Sir,
consent,
if the allegation is not that what he is doing wrong, allegation is very,
I understand. I bow down, Milord.
instead of 2.5 liter, he has sold 12.5.
Yes,
liter.
Milord.
That's the only thing.
Yes, Milord.
In one of the cases, the Supreme Court says like this, there can be no estoppel against the statute. The understanding of the government, whether in favor of or against the SSC, is nothing more than its understanding and opinion with respect to circulars. It is doubtful whether such clarifications and circulars bind the quasi-judicial functioning of the authorities under the Act. While acting in quasi-judicial capacity, they are bound by law and not by any administrative instructions, opinions, clarifications, or circulars. Law is what is declared by this court and the High Court. To wit, it is for this court and the High Court to declare what does a particular provision of statute say and not for the executive. Of course, the parliament or legislature never speaks or explains what does a provision enacted by it mean. So this is Bengal
Chemical.
chemical. And
Sir,
referring
I'll
to
also-
all, hidden chemical, and this is 1993, pre-SCR, 433. Yes, yeah, 1994, 2414.
94 Supreme Court 241. So grateful, sir.
Milord, one
I come.
His word or the two words?
Let's one more request for that. Since my lords have already granted entry model, but some more time may be granted, I'll also file my affidavit, my lord, in response. After all this was done, my lord, the inventory and all that. Not some more, since they have already got the entry model, there should not be any problem.
Justifying
That's
this,
it, bro.
Lord, I'll try my best. I'll try my best to, my lord.
I have read to you
My lord,
what
that
the
is
law
all.
is.
I don't.
So, my lord, my lord,
Item.
grant 3 weeks or 4 weeks, whatever time my lord feels proper. Some more,
Your question of
the question of law, my
For
lord.
your benefit, we can grant, no
My
demand.
lord.
Let it come if necessary.
No, he is your better fraternity. For some benefit, he wanted the opposition.
I don't object.
Drafting, then settling and. Yes. That would inure to some benefit. Is it?
My lord,
Is a beneficial one?
My senior is aware, my lord, the procedure that we have to go through, my lord, to.
It's not a procedure, something else. Yes, opposition would be then post it in a third week. Opposition by.
Rejoinder, sir, rejoinder.
Sir joined us.
Sir.
Sir joined us, sir rejoined us.
I think they are not contemplated. They are not.
No, it is there. It is this.
CPCA rejoinder is there. Not contemplated up to counter.
You will not find in the CPC, there is any concept of a pro forma dependent.
No,
element.
no. Yeah.
But
As a matter of practice,
it has evolved. It's by virtue of a common law principle.
So relief is claimed proper.
Proper, that's a common law principle.
Yes.
By judicial, may I use the word activism?
Yes. So we have learnt it from our seniors and we are percolating it to other.
No, there is one judgment of Calcutta High Court, where for the first time, the concept of this pro forma dependent way. So if I correctly remember, it must be 3 or 4 intergroup. That must be around 1898 or 1901.
1800.
1901. That it really emanates there. 1908 is the CPC which came.
Yes.
See now, which is there. Prior to that, there was a CPC of 1800 and something. It is 87 or 88. In between this interim, this was. So there are many things which are not fine, but it is, convention or the
Convention.
is a practice which has done that.
We have learnt it that way and we are going on following it.
No, it should be preserved. Anyhow, sorry, a little digression.
Item number 16.
It is relating to that one lifting of 180 ml. In spite of lot of.
There's Miss Patnaik, you are appearing. If you can give 180 is permitted, then why not 60? Why not 90? Why not 30? Why not 10?
Since long
What
I
is the
have not,
difficulty?
directed to 5 counter, at least 1 counter is sufficient to cover all 500 cases.
What's the rationale behind it? We have to see on the ground of Wednesbury's principle.
More the merrier.
If you completely stop, happiest, no difficult. But segregating, why? What is the rationale? There should be an intelligible difference here, something must come.
Already asked the department for a formal.
Yes,
answer.
I do not find that what it will give a benefit.
No policy for the present year.
Sir, otherwise it will be
Old-
dry.
Excel.
You declare it, no problem. That will be most welcome. To have a complete drive. But somebody, brother will not invite, he will say no. He will also not say. They will not be happy.
All will be happy. There will be drive, will very much will be happy.
No,
Not that.
that is personally, professionally.
No, professionally also.
State also, there is a loss of the
Professionally,
state.
Mr. Patra will be
We
the
have-
first person to say.
That's what I'm saying, professionally.
Long since 10 years back, I have said that. And thereafter, the Bihar government has introduced, but not the Odisha government. Though they have been during election, they have said, but till now they have.
Differential customs duty.
Which is 130 MPD.
No, my lord, it is that a certificate of origin from the designated authority should be submitted.
What is this case?
My lord, this case is that,
You are challenging any order of the tribunal?
yes, my lord,
So this is an appeal under section
My lord.
30,
my lord,
substantial question of law. What is that?
my lord, that I have. As at page 10, my lord.
One is sufficient enough. It is a substantial question of law.
My lord, is correct in law. Yes, my lord.
The tribunal has said that he is entitled to a benefit under the said notification.
Yes, my lord.
He has produced the certificate of origin issued by the Malaysia.
No, my lord, from the manufacturer. It is
is Malaysia Chamber of Commerce, but he has produced.
Now you say that it is not in conformity with the format which you have introduced.
Not only format, my lord. Not only format. He has obtained from the manufacturer.
So where is this notification of 1/7/2011?
Page 42.
Page
14, my lord, relevant rule is
Page 42.
42 is the
Rule 14.
rule 14, but my lord, what is that rule?
Yeah, rule 14 deals with reason.
My lord,
where
My lord,
where is the
if your lordship will go to page 32,
says
actually that page 32, the authority has quoted that rule 14. That is more clear, sir.
confirming the value.
May I place, my lord?
No, where it is?
Page 32.
Certificate of origin.
In fact, what has happened, my lord, in that
Just 1 minute.
Issue is authority.
Accepted as in the preferential by the affidavit of authority issued by the authority of the seas. Designate export by Annexure 2.
Annexure 3 and in the format specified in Annexure 4
man,
to these rules.
man. He has not obtained it from the designated authority. That is the belief.
Who is the designation?
By the Malaysia Chambers of Commerce, if your lordship will turn to page 49. Page 49, clause number 14. How exporter
49 is a part of the fact.
my lord. This is the part of the family.
So 3, 153, 44, Annexure 3, C rule 14. Their issuing authority is defined.
Yes, my lord.
Certificate of origin shall be issued in the format provided in Annexure 4
My lord.
to these rules
My lord.
by authorities designated by
Yes. That designated authority is
44.
44
my lord.
Issuing authority.
issuing authority. So the explanation for the purpose of subparagraph 1, the Ministry of Commerce and Industry, Government of India shall designate the issuing authority for the purpose of goods from India.
No.
But it
It's
is
an import.
imported. It is an import.
It's an import, my
So
lord.
where is the concept of import?
My lord, what has happened, my lord, because
I'm asking that there should be some guidelines, something of the import. It's an export.
if your lordship will come to page 32, my lord, 32, because my lord, what has happened in this rule, that page 14% is not there. But in the authority, in the order in original one, it has been quoted. That is why for convenience, if your lordship will go to page 32, that rule 14 is there. Rule 14, he has quoted that. Certificate of origin. Quoted that rule, 32, running page 32. Certificate of origin. A claim that the imported good shall be accepted as
So
eligible.
that is the designated authority of that country.
Yes, ma'am.
So who is the designated authority of the country?
Madam, that is there in page 49, clause 14. It is the Malaysia Chambers of Commerce or page 49. Running page 49, clause 14, question number 14. It is not clause, question number 14. It is the part of the FAQ, my lord, but it is there, my lord. Question number 14. Either MIT, Malaysia,
International Chambers of Commerce and Industry as well.
my lord. Much.
So they have certified that it is a Malaysian Chamber of Commerce. They have.
No, they have brought from the manufacturer, not Malaysia.
They have quoted in the order.
Yes, if your lordship will see,
They have quoted in the order that the certificate. This is that P.
page 18, my lord. May I place my lord page 18?
Yes.
From last, my lord. For subsequent
manufacturer.
from the manufacturer.
No. is being authenticated by the Malaysian Chamber of Commerce?
No matter. Nowhere it has been authenticated manner. It is from the manufacturer. That is the crux of the matter. It's a Chamber of Commerce, and I don't have any case.
The only objection raised by the revenue report is
It is not
it is not
in consonance with this.
under the exemption of petition and not issued by
By the manufacturer.
Malaysia. Mr. Adnan, do you have any instructions?
No, we not
No, he is appearing for the other.
You have no right of audience unless we admit it first. You will have the audience after we admit you.
As per page 44.
Whatever, anyhow, then we admit this is
Obligation.
we are admitting. So the
Both the appeals are
Both.
same, my lord. Two bills are there, so.
It's only separate orders to be.
Obligation.
Item 21.
21 minutes. The issue is that the bid petition is entertained after the expiry of the appeal period. That is pending, that matter is kept to 10th of November.
Fix something.
Item 22.
Yes.
Item 23 can be taken up next week, Lord. On behalf of Mr. Tripathi,
Item 24.
24 minutes regarding non-constitution of GST.
We have already. There will be a separate order for that, on the basis of the. Notification.
Yes.
Item 25.
If I received the instruction today, man, I may be allowed 1 5.
Item 26.
My lord, after that, they give us a file a rejoinder. My lord,
What?
Yes.
Yeah. After, by next week?
Yes.
Rejoinder by 1 week thereafter.
My lord, we are also filing an affidavit reading certain documents. I will file it. Interim order. My lord, that's all.
Item 26.
In case 6, your lordship, you will be permitted to withdraw. The filing is moved.
No interim order.
Nothing. No need to worry.
Item 27.
Wait, please,
Execution. Listener. Include. The demand notice on the annexer 1 at page 27. Lordship may kindly. See the
Assessment year 2007-8.
7-8 they have mentioned, but later on. In the
They have
table,
included
after form. They have. Lordship will.
They have included many.
Many. And. They have imposed. Those are the interest portions they have imposed. Under section 220 bracket 2. Then 11, 12, which recently has been quashed. The demand has been quashed by a bench of this honorable court on 8th of August 2025. To my lords, for sake of brevity, I'll take your lordship. A CIRP proceeding under the ITC Act was against the petitioner.
Was it admitted? Was it admitted?
Yes, yes. It was admitted.
Resolution proposal.
Yes, yes. Will appeared
And
and the resolution plan was approved.
the
by-
COC has approved the
Yes,
resolution.
yes. That is, I, Lordship may be pleased to see the order of the NCL, which is the adjudicating authority under section 5, and the NCLT, annexer 8 and 9.
Yes.
At page 250, resolution plan under annexer 7 has been accepted.
True, that's why I said.
Yes. Now, my lords, what happened? I demonstrate with your lordships how this demand, these amounts which have been included in the demand notice are legally not sustainable. First, I will take your lordships to an assessment order was passed for the assessment in 11-12 at page 295, 285, I'm sorry. Then that was challenged before this Honorable Court. And this Honorable Court, under annexer,
11,
beg your pardon, ma'am?
that is for assessment year 11-12.
11-12. Whereas demand of rupees 7 crore 71 lakhs, something was raised. Then I challenged the same, which was dismissed under annexer 11 at page 290. Then what I did, my lords, I filed a review petition. The review petition was allowed under annexer 2, page 27, my lords, by a bench of this honorable court, and the demand was quashed. So 7 crore some odd goes. Now I communicated this to the assessing officer, that is annexer 12 at page 294. I have communicated this. But
Just 1 minute.
annexer 2, I will pleased to, I may be permitted to place it before lordship. It starts from page 27.
No, I'm already at page 39. Don't worry.
Yes, yes. May I bring your lordship to turn to page 44 of the said judgment?
I have already.
Yes.
I'm at 46, sir.
And that is ahead.
Sir, the basic question is raised. Those two of the judgment of the Supreme Court says the moment the resolution, the company has gone under the IBC, there is a moratorium period. It suspends any legal action to be taken. And all dues which has not been included in that would get effaced. Yes. That would go. What is required even to an income tax authority is to approach the IPR, lodge your claim, be a committee of creditor or become a creditor, and then you proceed on that because the resolution plan must contain. Because these are all the cases of the pre-resolution plan.
Yes.
Then it says that your claim is not sustainable. Exactly. Oh, tell me, we are nodding the head will not do. Tell this is a law which is
I have to go through
Ghanshyam matter, then the Vaibhav. These are the matters Supreme Court has held against you. Then this demand is not sustainable. Why you did not place that case? When the resolution plans, when the IPR was the application was admitted before the NCLT.
It was on 30th of January 2017. 17.
Okay.
And I have given that order, my lords, Annex 5.
Admitted.
Yes, admitted.
The
Then
past
hierarchy was-
it is not included in the resolution plan.
They
That's what
did not lodge any claim pursuant to the publication.
please go through it. It can't
Right,
be.
right.
It can't be. What is
Respect of this particular part, also this court has
Yes,
division.
it's been sustained by the Supreme Court. I'm given by Justice Nagaratan. These are the judgments. And that's also honestly.
Which was the judgment?
Yes.
Division.
Yes, yes. My lord, sitting on the justice, you be that.
I was party.
Yes, yes.
Correct.
Yes, yes. My lord, that judgment of my lord.
That also another judgment.
Yes, it was approved by the Supreme Court in this judgment. This is an order, can say it's a judgment, but the Honorable Supreme Court has called the observation of Ghanshyam Mishra for 100 of the judgment of Ghanshyam Mishra.
No, Ghanshyam is very clear. This Supreme Court has also relied upon a Ghanshyam.
Yes.
2021 Volume 9 SCC case 657. It clearly says that the moment the resolution, the adjudicating authority such as the claim is provided in the resolution plans and stand frozen and will be binding on the corporate debtors and its employees and all, including the central government.
Subsequently, the rainbow.
Any state government or debtors or something.
Different. The rainbow paper was also subsequently.
Yeah, diluted.
No, that was also
Yes,
distinguished.
yes,
On a subsequent note.
yes, yes.
Following Ghanshyam Mishra.
Yes.
Why you did not raise this point before the authority?
Manners, they are aware of this, but still then, they are proceeding just to extract.
What action?
I mean, manners, because they will show that these are the demands.
There is a conscious pause.
Manners know it
That conveys a very laudable message. So
I think, sir, you have been conducting case of this particular petitioner
Yes.
since 10 years. I have been.
Starting from this sheet,
there is a very big order is under challenge.
Manners Annex 1, the demand notice. They have,
So we are staying the demand. The notice of demand.
Item number 28.
Extra copy, madam.
Sir, I have not accustomed to this concept of extra copy or a less copy. I'll serve once a copy is served, that's enough. Now it is a standard. It used to be here.
Yes, sir.
For standard.
Item number 16.
Sir, put her on this floor. 73.
No, item 49 will take about 3 p.m. Next item actually called at 3 p.m. Item number 30.
May it be your worship. My current scenario is out of station, so I am praying for the adjournment of.
Can an adjournment be granted on the ground of senior? Yes. Under order 17 rule 2 of the Codes of Procedure. Can it be granted?
Is my.
Yes.
Sir.
Give it. To be a C. That is engaged in another court can't be wrong, so his outer station can't be wrong. You are here, so I will come to the process only.
I done my best. I'm honored about the.
Who is the advocate in the court? I mean, who is the Vokanathar?
Mr. Anand Narayan Patnaik.
Only. Or somebody else along with him. What's your good name?
Sambit Kumar Sahu.
Huh?
Sambit Kumar Sahu.
Oh, your name is not reflected.
Not there.
Huh?
It's not there.
But on the not a good crowd for that. Yes. Pradeep.
Item 31.
I did an application for modification lordship order dated 29 July 2025. The order dated 29/7/25. Actually, what has happened to lordship kindly this IA this 14316 of 24. The IA is at flat C.
What's wrong?
The final your lordship said that I may be related to release of the sorry, by allowing me to leave the iron ore and fines. Well, also referred to in the iron ore, but in the ordering portion only fines. Therefore, they are not allowing me to leave the iron ore. So I have deposited everything and all that. Fines have been allowed. But
We were flexi.
yes, flexi of 141 double PC 14146
In the connected
143
You know?
14316 of 24. Yes, hard
Yes,
case.
yes, yes.
No.
Well, at the election, can you permit to place the order, my lord? For order dated 29 July 25.
Sure.
They are referred to but because I don't know quantity
Yes.
instead of I don't know fines. My lord, your
Why you are so technical?
My lord, regarding the government, whether it is allowed or not, that time, my lord, it can be corrected, my
So
lord.
he has asked for that, since it was the minor ore, has not been, or fines has not been given, so they are not permitting.
Fines have been allowed, but I don't know if they're not allowed. Because not there in the orders. Last order we proceeded not there in the para 5 of the order.
There is our order dated 29.
29 July to 25. 29 July 25. Para 3. May I permit to place it? At this juncture, the Lord Senior Counsel appearing for the petitioners submit that they have taken out an interlocutory application number I number so and so for direction of the opposite party to permit the generation of e-passes per iron ore quantities already extracted and restoration of the fines. Then you'll also really see para 5. In view of the above, we therefore allow the instant interlocutory application.
Oh, look, I don't know quantities.
Quantity also was included. Yes, included. But in the order by para 5 will also be directed.
Yes, that is omitted there.
Yes, that.
What the authority? We have already recorded this paragraph. If paragraph 5 only, I don't know fines have gone. And not this, I don't know quantities. So they wanted this. Huh? Yes, sir.
No, most of this.
32.
Well, the petitioner or the licensee, country liquor shop. But the excise liquor, country liquor. It could not meet the MGQs. Then there was a demand. There is a demand raised by the state to the tune of rupees 2 crore 26 lakh. Some odd amount.
Nice series product.
Because it is made for lots of local country. Then, my lord, I approve this honorable board. Because the direction is paid 50%. I paid the 50%. Thereafter also I paid next 50%. Entire demand amount I have already paid. With fine, my lord. As for the section 34(8) of the excise rule says, if anybody somebody bought, there will be a fine of 10%. That 10% fine also have to pay. But the question, my lord, they have not yet allowed to leave the corresponding MGQ of liquor.
Because the last instruction that we had was that in April 25th, we had not paid.
Whatever they have deposited, whatever the amount, will they not, are they not entitled to lift it? If they have paid the entire money.
It has been reviewed, your lordship.
Yes, license.
Because
Will
the instructions that I have.
come on 27, will the instructions come from?
All right. Also the batch is there was the direction to meet the corresponding MGQ. Like one of the coordinate benchmarks.
We have completed 32. Yes, we-
33.
The condonation application. Service,
Is dealing.
service has been effected. Where?
21 I have searched the copy. Unless you are extending to respondent number 1 to file objection.
What? No, not yet received. R1 has not received.
Like 21st, I think. Yes,
As well as the early of the learned advocate for the RA not yet received. Have you served upon him?
I received questions and all yourself.
Mr. Mukesh Nair, can you secure his presence?
And I will intimate your ship. Learn
Sure.
34.
34.
Service.
Service has been effected, madam.
Where-
On 29/25, receipt is there. Yeah, I have already served on the land council for the. This month is appeal.
No, we are running beyond time. I do not know, they must be having. I mean, behind this particular period. Thirty-five? How many days they will?
94 days.
I have no objection.
Yes.
This is the application for condonation of relief. Maybe for the waste in the field. Nomination provided there. Yes.
Item 36.
Condonation.
36.
There is a delay. But a Luca supposed to be there. Yesterday's matter, your lordship have directed that the application for limitation will be considered as the stage of admission.
The next 37.
At 37.
49 days delay. 49 days delay.
Yes. Somebody say.
Yes, I am.
You are appearing for the opposite party.
Yes, please.
Yes. 49 days.
Compassionate appointment will be considered early date,
31st.
31st of this.
Item 38.
Request this matter may be passed over.
Any days delay or have you served? Yes.
Yes. We had 33 days.
38.
You are there. How many days delay? 30?
38.
38 days delay. Yes.
Sorry, 33 days.
33 days. 33 days delay. Yes. Though 31st for admission. 31st for admission.
Next notice for withdrawal. Item 39. Yes, ma'am. Yes. File the memo is there. At 9 that day.
Lord, I am extremely sorry. I was in serial number 34. I was in virtual mode. At that time, the computer, the operation, the virtual could not I attend. That was the difficulty. But in that case, that's a delay of 11 months in filing the writ of appeal. Lord, I had this notice.
Audition.
I will file the objection. I have. I'm the appellant. It is the writ of appeal they have filed. The government has filed.
Objection.
On the face of record, Lord, 11 months delay.
Are we for the basis of what they have stated or we want to find you objection?
Also, this matter, 11 months delay, they have not a single.
To take objection to is your baby, you have to nurture it. Take a decision.
For long That is what really. Okay, Miller, I am filing this objection even like today in this court, Miller.
Give the copy to him.
Yes.
File rejoinder, you file rejoinder.
Yes. Not fix a short date. Miller. Date is
49.
today.
33. 33.
Because in item 33, copy has been served on us. We have received the copy. We are filing an objection to the limitation petition filed because there is a delay of. I have served a copy on her.
36.
Yes, my lord, 112 days.
I'm also asking directly both reach appeal and
The
I should have simultaneous.
one merits. Here, my lord, the service of the petitioner has been regularized from 2015. All that he claims, the service should be regularized from the date the service of his juniors have been regularized, that is from 1992, my lord.
99.
99.
What the single bench did.
But the single bench allowed the writ application. But however, a single bench didn't refer to any statutory provisions.
Is it based on a common law principles? There may not be a bigger problem, but based on a common law principles.
So, my lord, here what has happened, my lord?
His entitlement was in the year 1992. And the juniors have already been regularized, but there was some, I have a very bad words always come in my mouth, so I just restrain myself from saying those. You have spared him, did not give them what you did that. Then in that event, why not from the day when
But
the juniors were regularized?
But the Orissa local fund service rules, that rule where the vacancy is required to be filled up through a selection board. Admitted.
Discriminatory. We
No,
will
my-
not follow the seniority. Somebody who is there senior, you will pick and choose.
No, there is no pick and choose method. No pick and choose method adopted. Your lordship may hear me for a moment. Only. Here what has happened? These petitioners also his juniors, around more than 500%. They were all continuing as DLRs, daily rated workers in municipality, Cuttack municipality. Then subsequently, government came up with a notification that to regularize the service or to bring them to a regular establishment, government took a decision in 99 that we will fill up the vacancies and regularize their service, bring them to the regular establishment, but by virtue of the provisions as contemplated under the statute. Now, in 1999, an examination was conducted by the selection board. That examination he could not appear. Then immediately thereafter, he ventilated his grievance to the director of municipal administration that for so and so reason I could not appear in the examination. But subsequently, the order of regular appointment of those employees who had appeared before the selection board and were sponsored by the selection board, the order of regularization was passed. My learned friend approached this honorable court. This honorable court directed to consider his representation. the Director Municipal Administration took a decision on his representation. They found that since invoking Rule 7, a selection board was constituted and conducted the written examination and viva, and you could not appear in that. So whoever has appeared, he has been regularized earlier to you, and you have been subsequently regularized.
Did he appear subsequently?
Subsequently, he appeared, and he was regularized in 2015.
Any examination was conducted when he approached the
Authority, he approached, my lord, that is that annexure.
This is also kind permission, my lord.
He's a appellate, he has a
Lordship may kindly see annexure 4. This is the page 30, the letter addressed by the petitioner to the Director Municipal Administration.
Annexure 4 of what?
Annexure 4 of the appeal petition.
I do not find any annexure 4.
I'm sorry.
It said annexure 2.
Annexure 4 to
I'm sorry, sir. Annexure 4. Annexure 4 to the petition. Page 30. Page 30.
Yes.
Lordship, may kindly see that I have been working as junior assistant NMR DLR basis since 1/11/1990. I am discharging my duty with great satisfaction, which is entrusted to me. I have passed BA in 87. That it is necessary to mention here, with that due to some official unavoidable circumstances, I was not directed to this test conducted by the selection board on 28/9/1997. So here he admits before the director that he could not appear in the selection board.
He has blamed you that he was not directed.
He is a municipal employee. Here the regularization has to be done by the state government. He was continuing under the CMC. CMC didn't allow him for some reason to appear before the.
But once he approached in 1998, what you did immediately within 1 year.
Lordship, may kindly see 99. In 99, the persons, those who had already appeared in 1997, an order of regularization was issued by the Housing and Urban Development Department, Government of Odisha. Annexure 6.
When by this time he has already approached you.
He had approached the authorities.
Right.
Then, my lord, when his grievance was not considered, his case was subsequently considered for regularization in 2015.
Why you took such a long time? Now 1998 or 1915. How much time you consumed? Just tell me.
My lord, pursuant to the direction of this.
17 years you sat over it.
No, we didn't sat over the matter. He approached this honorable court by two. 98, my lord, pursuant to the direction of. Yes. My lord, pursuant to the direction of the honorable court in WPC 8928 of 1999, that case was considered the Director Municipal Administration and rejected. Challenging that order of rejection, he again approached this honorable court. That rejection order was quashed by this honorable court, and matter was again remanded back to the authorities to reconsider his case. And in the meantime, a committee meeting of the CMC was conducted, and his case was again recommended. And pursuant to that, the selection board, his case was considered by the selection board, and he was subsequently given promotion in 2015. I mean, 2015. So thereafter, he approached this honorable court 3 years thereafter in 2018.
Considerable 16, 17 years. of a prime time of service. You are still on call, retired.
In the meantime, I was retired
When?
in June month, June 2025.
During the pregnancy.
During pension. 70 juniors getting pensionary benefits.
I understood.
The only grievance that service has been regularized after one.
Be a global employer. On solitary.
But there are many ones.
That is the one solitary.
Retrospective regularization he's claiming is not that his case.
Can he not? Where is the bar?
When he has not appeared, when the government
They say that he was not really directed because he has to be communicated to appear. I did not. Immediately after coming to know, he exposed the authority. That was the thing. That he is in the position to permit me to appear. I would have understood that instead of 1997, when you regularize the other juniors who appear in the examination, you also permitted them to sit in the examination. And then he can be regularized from 1999 or 2000. But the gap of 1998 to 2015 is nearly 17 years. And a qualifying service he does not have. So not entitled to a full pension. What is a full pension? What is the qualifying service?
Minimum pension for 10 years. Minimum pension.
That is not a full pension.
Full pension 30
years. So you have.
And he is only grievance
in 25.
So,
from 2015 to 25. So 10 years minimum pension he is entitled, but that is as per the CPF pension because he was appointed after 1/1/2005. That is pursuant to the amendment in the Orissa pension rules. He claims if his case is regularized from the he will get the full pension. That is only the case. But in a similar nature of case, the Lordship may kindly have a glance to the judgment.
the lordship judgment is a whole lot case. The lordship, there should not be any discrimination in recent judgment, 30-page judgment, your lordship's judgment. Whole lot case also.
Arunnath case is different one. Arunnath case, there the gardeners, they claimed for regularization. Their cases were not regularized because they were continuing as DLR and there was no sanctioned vacant post, referring to the judgments of this one. But here in this case, the Lordship may kindly see a judgment 2022-19 SCC 662. Lordship may refer to the fact of the case. Para 4. Para 5 here, Lordship may kindly see. The respondents herein by the office order dated 29/6/1989 were regularized and allowed regular scale with effect from 1/4/1989. And as per the recommendation of the screening committee, the relevant portion of which is so and so, so and so. Then para 6, the respondents filed SB civil writ petition number 5326 of 1990 before the High Court of Judicature for Rajasthan at Jaipur bench against the order dated 29/6/1989 passed by the appellant seeking regular pay scale with effect from 1/4/1983 instead of 1/4/1989 by contending that they could be compared with those employees who had been fixed at the regular pay scale by office order dated 15/10/1987 instead of 1/4/89. The High Court by its order dated 6/5/2005 allowed the writ petition which has been confirmed by the division bench. Then para 8 is important, my lordship may kindly. So it is the settled position that the date from which regularization is to be granted is a matter to be decided by the employer, keeping in view the number of like the nature of work number of posts laying vacant, the financial condition of the employer, the additional financial burden cost, the suitability of the workman for the job, the manner and the reason for which the initial appointments were made, etc. The said decision will depend upon the facts of each year, and no parity can be claimed based on the regularization made in respect of earlier years. And
Have you disclosed in your charter that when you undertook the exercise in 97, the number of vacancies were more, or when he approached you in 1998, there was no vacancy position? Have you disclosed? When you are taking shelter under the judgment, then you have. This judgment is based upon that.
But this
Did you
judgment,
disclose that there was no vacancy in 1998 or in 1999?
but vacancies was there to
So-
fill up those vacancies.
The only thing is that is why it says that Supreme Court has found that here the grade after 2 years or have completed 10 years will not do. This regularization has to be against the sanctioned vacated post. When there is no vacancy, there is no obligation of the government to regularize them from that date. And then it says that you cannot claim parity because each year the vacancy has to be ascertained. And if the vacancy in that particular year was not there, then the regularization cannot be done on the ground that I am claiming parity of the earlier year. So this judgment has to be read in the. These show us that there was no vacancy in the year when he claimed.
But
I will accept that. But when he come up, the selection committee was there. Will he not examine him? Will he not take up his case?
But if your lordship would kindly have a glance to that para 8 of the judgment once.
Please read.
Yes.
I'm talking about before you read paragraph 8 in that line. Please read.
Well,
Yes, read paragraph 8, please.
Yes, para 8 says, it is the settled position of law that the date from which regularization is to be granted is decided by the employer,
Yes.
keeping in view number of factors
Correct.
like the nature of work, number of posts laying vacant, financial condition of the employer,
Yes.
the additional financial burden cost.
Yes.
This line is important. The suitability of the workman for the job,
Correct.
the manner and the reason for which initial appointments were made, and etc.
Correct.
Then the said decision will depend upon the facts of each year and no parity can be claimed.
Correct.
Now,
Why?
so far as the suitability of the
Sir,
workman for
come
the
to
job,
paragraph-
yes,
Don't skip paragraph 9.
this court in Jodhpur Vidyut Vitaran Nigam Limited versus Nanuram has held that the employer is required to examine the question as to how many workmen could be regularized, keeping in mind the budget provision, availability of the post, the number of muster roll workers engaged in construction work without there being existence of any vacant sanctioned posts, and the manner in which these muster roll workers were initially recruited, that is, whether with or without the approval of manager. Thereafter, examining the above, the employer has to recommend their absorption in regular service on the basis of eligibility as determined by the screening committee. It was held that mere completion of 2 years is not the only criterion, and that the state is not under an obligation to constitute screening committee at the end of each year. Constitution of the screening committee is within the discretion of the state government, depending upon the opportunity.
It says the sanctioned vacant post.
Yes. My lord, not only sanctioned vacant post, but also the suitability and eligibility of the candidate.
Suitability means unless he is put before the screening committee, how his suitability would be judged, how its eligibility is judged when you do not invite him before the screening committee. You never constituted the screening committee.
My lord, screening committee was constituted, but the number of NMR DL were answered by the CMC, they appeared in the before the selection board. But so far as the petitioner is concerned, he could not appear for some reason because the CMC.
You did not sponsor.
Well, not we, it is the
Yes, that was
CMC.
clear.
Your Lordship may kindly appreciate. It is the CMC who could
Why don't
not
you-
sponsor him on time.
One is an alter ego of another.
See, to regularize the PhD manner or in a serial team, then why should you skip over? It is you to look to that all they are coming in a serial and appearing.
But those candidates who appear, they have been given adequate opportunity to appear and they have participated. And those name of those candidates were also recommended by the CMC. So far as the petitioner is concerned, 97, and subsequently he.
The question is twofold. One is that once he is found to be suitable, then he is suitable since the date of an inception. So question is that how to be adjusted. Now you have given a regular the effect of particularly. He wanted to be given from a retrospective. Now the question is with this. The passing of the examination is a sine qua non.
Yes.
Is the fact. So he has passed the examination.
He has passed the examination subsequently in 2015 and his service was regularized. Not on the date he didn't appear.
Say, what do you have to say about this judgment?
Before the judgment, about lawsuit kindly permit me the actual fact. My knowledge friend is wrong in saying, with due respect, that I have not appeared. What I have humble submit. My case was rejected on the ground that the court of
What he says is, I think you have to just ponder upon when you use that word, is not correct. What he says is that in 1997, the screening committee conducted the examination, you did not appear. Which is also admitted by you in your letter when you issued when you issued in 1998.
After 1998, 1999, another examination was held. And in that 99, so many juniors were regularized. I filed a representation and they have not considered. And I came, they have rejected my claim. This honorable director for consideration, they rejected my claim only on the ground that the Kotak Municipal Corporation did not sponsor my name. Only one ground. And this honorable court held that Kotak Municipal Corporation sponsored, you did not regularize, they did not consider, and that rejects.
Actually, it was found that the Kotak Municipal Corporation sponsored your name.
Yes, my lordship can.
1998 or 99.
1998.
Did not sponsor.
Where is that?
Sponsored, he says.
No, he says
this
he
is
did
the
not.
Rejection. He says that the rejection was that it did not sponsor his name.
Yes.
But he says that the court held that yes, his name was sponsored.
No, well,
This is what I understood from his submission.
That is page 73, your lordship rejection order kindly see. The read petition. May I read your lordship? The name of the persons engaged in urban local bodies as LMR DLF ad hoc basis but interested to work junior assistant between the period 10/9/82 to 36/92 were called for the consideration cases for regulation of the services as junior assistant, but the CMC did not sponsor the name of the petitioner. On this ground, they rejected my claim in 2009. I filed writ petition. This announcement quashed, holding that the CMC sponsored my name, you did not consider.
Where is that?
That is judgment annexed. The writ petition page 76.
Please
read
show that particular finding.
Man. page 77 of the petition I'm reading, my lord. Considering the contention raised by the Honorable Counsel for the parties and on perusal of the materials available on record, it appears that the name of the petitioner has been duly recommended to the state government for regular absorption by the Annex 8 and 11, and he has rendering service during the period from 82 to 92. Without considering such document, the impugn order has been passed in Annex 13 by stating the reason that the Cuttack Municipal Corporation has not recommended the case of the petitioner, which is an outcome of non-application of mine by the state authorities. At the same time, similar question came up for consideration before this court, wherein this court directed regulation service of the petitioner at par with juniors. In that view of the matter, the impugn order dated 14/9/2009 by Annex 3 is passed, and the same is remitted back to the authority to reconsider the case of the petition on the basis of recommendation.
Actually, if the court has recorded, it's a judicial recognition of the fact. Can you differ? If the court has recorded a fact, can you differ?
Next is 8. Next is 8 and 9.
Why you will go into it? It's a recognition that in fact, when the court says in fact it was recommended, that's it.
The court only says it was recommended, but whether on the date the state selection board conducted the.
Sir, he says in 1999, there was another examination which was conducted by you. Then in 1998, if the recommendation was there, then why he was not permitted to sit in the 1999 exam?
On many occasions.
On many occasions.
2 occasions. Yes.
Yes. Anything more you want to highlight?
I have been the written notes, my judgment. So many juniors have been regularized. I have also made.
Where is your written notes here?
That same judgment, that page 77, my client was referring to, that your lordship will find at page 77. That is the submission made by the learned senior counsel for the opposite party 3 and 4. Strenuously urged that Cuttack Municipal Corporation had already recommended the petitioner on 2/7/1998 and 5/4/2008 by annexure 8 and 11 respectively. Therefore, the contention
Senior counsel is
Mr.
there.
was
Will
appealed, but
he deny that this is not the state of this court?
He does not remember.
Mr. Mahathi.
He does not remember.
He usually appears.
the second recommendation was only in 2008, and the other one after the first.
Renovation allowed. Yes.
that eviction matter. So Lordship had this matter because of the intervention of their vacation or Lordship the police force. So Lordship in that day said that if state government is unable, will report directly city.
SP has agreed to enforce, but the victim what happened last time Tahsil appeared. Now in ICU, my lord, unless he's come.
He was born in ICU.
Tahsildar.
After he was called here.
That will be managed by ICU there.
2014. Only for
Your lordship may fix some time, we will do it.
Fix a time. How many times we will fix?
Your lordship last time said that we will pass the order, and unless there is any stay order operating, then they are open to them to make the eviction. Your lordship, 1 month time your lordship gave, will evict it. Provide force and
All the steps have been taken. The order of
Yes.
eviction is passed.
No, man.
Obviously, he has been repeating.
I may allow to comment on this. My lord, I may.
Everything is completed.
No,
They are given notice.
no,
They
no,
are not evicted.
paper is filed in a court.
Only deputies.
My lord, I.
Put an end to the this.
Your lordship extensively hard on 16/7/25.
No,
What no?
no, I have not submitted.
Yes, completed his argument.
We understood.
That
He has not betrayed me as of now.
man.
I if simply he argues fully, then I say that we'll pass an order.
Well.
Say that whoever has not suffered an order of eviction by
Well.
Silla, definitely his property
Obliged,
cannot
yes.
be.
My lord, I am giving that
demolished.
recently.
Those who have suffered an order,
Well,
definitely
Well,
that has to
well,
be implemented. This is what we said.
Yes.
what means that the recent condition that bulldozing justice. The
That
entire
was
scheme
good.
has been prepared.
What is key?
That's why I'm. Touching the Supreme Court judgment, man.
What is scheme is
In
prepared?
the demolition matter.
But who has prepared the scheme?
Well, that Supreme Court decision, let me come to the last part.
Yes. Sir, this is it.
Well,
This is in relation to something else.
no, my lord, this is entire part regarding demolition, my lord. They cannot do without adopting the process of law.
Change the name slightly, my lord, and also the executive director, the new executive director under the new management. So, my lord, there will be an amendment to the cause title, which your lordship may kindly permit us. And, my lord, more importantly, the reason I am troubling your lordship.
Now resolution plan has been accepted.
All done, dusted.
All done.
Everything is done and dusted, my lord. So there is now, my lord, the only issue before your lordship is the issue, my lord, of the mining lease execution, which is what
That has to be done because now it has really merged into this after this. So
That-
if the
that's
name
right.
has changed, then incorporates.
No, my lord, the only
We are
problem
allowing
is
this amendment to be incorporated.
The application, they have not served the copy.
my lord, we'll do that right away. It's just a ministerial thing, my lord. We'll do it right away.
It is very formal in nature, I know. But he wanted a copy for some good purposes.
Yes, my lord. My lord, I appreciate that. I'm sorry that, my lord,
Give
I
him a
think
copy.
I do it right.
my lord, my learned, my local counsel is there in court, my lord. He will do it immediately. The reason, my lord, I was troubling your lordship today, my lord, is if it's possible for your lordships to kindly consider, my lord, final disposal of this matter at the earliest, because we don't have a mining lease today. And my
No,
lord,
no,
while there is
we'll do it. We'll do it. I am. If the councils are ready, I am ready to dispose of.
pleadings are ready. I was, my lord, wanting to come down and, my lord, if possible, my lord, have the privilege of appearing in person
First
before
week
your
of
lordship.
November, do it. First week of November, do it.
Could it be 24th of November, my lord? Would it be possible, my lord, for 24th?
Oh, no difficulty.
My lord, I'll be so grateful.
Readily welcome this.
I'll really be grateful, my lord. 24th November, then, my lord, we'll complete all pleadings by then and be before your lordship, my lord. And
This is an application. This is a Yes. Yes.
True.
Yes.
Also, if they kindly have a glance to the earlier direction of the Honorable Apex Court on 3rd April 2020. That is already there on
Next
my
step. Next step.
That order
Now this is the subsequent order.
that is a subsequent order in the contempt proceedings filed before the Honorable Apex Court.
Yes.
Now, my lord, I have some.
So, no, please argue the matter and argue the matter. Who is the appellant?
We are the appellant. Here are some developments. You can also make.
I do not know. The last sentence of the present order is. Please read it.
Another copy is there.
So give it. The Supreme Court order, last sentence.
Because nobody, on
Please.
behalf of state, I have gone through this because on the date the matter was taken up before the Honorable Apex Court, nobody was representing the contempt.
So that is, I don't know.
Today morning only my learned friend intimated me that there is some order by the Honorable Apex Court, and immediately I have conveyed it to the department, and they have also complied to some extent. Well, lots of idea for the answer. The earlier part of the order passed by the Supreme Court, if your lordship may kindly have a glance, that is a little bit important. The para 7, the Honorable Apex Court observed that suffice to protect the interest of the appellant by directing the state of Odisha to deposit the balance amount as per the rate determined by Justice Patra with the registry of the Honorable High Court during pendency of the first appeal. The said amount along with any additional amount earlier deposited shall be kept by the High Court in the form of a fixed deposit receipt.
Sir, we do not want anything. We just want the
In the
Supreme Court has
meantime-
said that you should commence the hearing. We are commencing the hearing. We have to commence the hearing. You'll have to start the hearing. Have you seen the order? So
Yeah, with the copy of the order, because no
whatever, then we'll have to proceed.
meantime, let me first because
So this is what the observation. Meanwhile, we request the division bench of the High Court to take up the first appeal number such and such, preferably on a date fixed, that is 15/10/2025, which is today, and commence hearing for its final disposal. So we'll have to hear. And then second line is also very important. In this regard, the High Court need not to accommodate the parties seeking adjournment. We are bound by the judicial order.
not seeking for the accommodation, but all that I am
Commence the hearing. Commence the hearing. File is bulky or small? It's small, this much. Yes.
Page 51.
What? Page?
Page 51. This appeal arises out of the execution petition number 2 of 2015.
No, this was the final judgment. It has not been upset by the court. this judgment of 21/5/2009. You are referring page 51.
51,
Yes.
not upset.
OJC number 11342 of 2000.
Yes.
Yes. So what was the order which is impugned, passed in the execution case?
And 11/8/2017, my lord, and the execution case.
Where is
2 of 2015.
That is at page 158.
158? $158. $159. That is 11/8/2017.
The order starts from page 160.
No. Is an order dated 11/8/2017.
Yes, ma'am.
Where is the order of the apex court of 9/1/2013? Which page?
35 to 36, my lord.
Huh?
35 to 36 of the appeal.
35.
What would be compliance of the order, that is at page 36. Content of the
Just. So the executing court has exercised its discretion and reduced it to half, from 14 crores to 7 crore per acre.
It was made on the submission of the land government advocate.
Who is the appellant?
There.
So, this order.
No, Miller. Therefore, he had gone to the Supreme Court.
Against this order?
Yes, Miller. This 11/8/2017 order, we had challenged to the Honorable Supreme Court.
What happened?
3862 of 2017 were filed and 3/4/2025. This order was passed directing this matter was referred to your lordship as the appeal was pending here. Lordship to decide the matter as regards to the valuation of the land, whether it is 14 crores. They have challenged their own order, my lord, that submitted before the honorable court that the value of the land is 7 crores. And accordingly, considering the submission of this court is of the view that benchmark valuation of the land at Jayadevia and Bhubaneswar fixed under the Odisha Standard Amendment 1 appears to be fair and proper method of determining the market value of the petition.
Accordingly, while accepting the market value of the petitioner land as rupees 7 crore.
This was submitted by Lord Council on behalf of the appellant before this honorable court in this execution petition. So that was accepted by honorable court, and they did not accept our submission of the value of the land is 14 crores, for which we prepared an appeal before honorable Supreme Court.
Now the difficulty is very Now, where is the order remanding the matter to the High Court? To hear out, where is the order?
That is the
3/4/2025.
April 2025. That order is there already.
Where?
There is even an IA number 3.
Where is the order of the Supreme? Just. It's a bulky order.
No, not a bulky. It's a 2-page order, but it was in my record.
I wish the certified copy of the order.
No. No, tell me.
Absolutely, kindly see that order passed by the honorable affection. I'm referring to that order. That is why I filed this instruction. This order, my lord, para 7 of that order.
The deposit of the balance amount was there. You have deposited
We have not deposited. That balance amount, we have already received the concurrence of the finance department. And that 15 crores 71 lakhs 80,000, we will deposit in the meantime if some time is granted. So that is why I have published that on production line.
There was any time limit which was fixed here?
No time limit was fixed.
Pending subject. During pending subject.
During
No difficulty, you deposit.
that has to be deposited before the registry of the.
No, that is a separate issue.
Yes.
We'll get argue
And the.
on merit. Now the question is that there was say an officer appointed by the Supreme Court for determining the market value of the property as on the date. That is 2013. Now the officer has appointed by the court has determined the price at 14 crore. Now the executing court, without recording its satisfaction that why it should not be 14 crores or why it should be a 14 crores, abruptly jump to the conclusion 7 crore is there. If that being the position, then how this order is a absolutely non-speaking order. I think the evidence has to be taken into account. The exemplars, I think the special officer appointed by the must have taken into consideration the exemplars, meaning thereby the sale deeds or something of the nearby locality.
But the Supreme Court directed for the appointment of a
Justice upon High Court.
Justice of the Sikkim High Court, who in fact was the judge of this honorable court.
And the executing court has.
The arbitrator fixed the benchmark valuation at. So far as the honorable single judge in execution proceeding fixed the.
It was not an arbitration proceeding, I believe.
But that what the Supreme Court has directed now, that
simply send the matter to a particular the authority to decide the market value. That's all.
To decide the market value based on the market value fixed by the arbitrator or by the honorable single judge in the execution proceeding. That is the only issue which is to be decided.
Here,
yes.
If the Supreme Court has point for the purpose for determination of a market value, what more?
Your Lordship may kindly.
What more?
What the honorable court has directed, your Lordship may kindly see.
Please.
I just
para 6 of the order.
Yes.
In our considered opinion.
Yes.
At the facts noticed above.
Yes.
Would speak for themselves.
Yes.
The issue regarding fair and just market value of the land is pending consideration of the High Court in the above mentioned proceeding.
Correct.
While the appellants will be at liberty to contend that the High Court in execution cannot go behind the determination of price of justice.
That is what I am saying.
Patra, the state will be equally entitled to contend that the report order determination of Justice Patra suffers from
Sir,
some
this
legal
is
flaw.
what I say. So that the only scope is that whether the price which is there at rupees 14 crore is justified or not justified. We just argue on that. Justified or not justified. What are the flaws? What are the where is the determination of Justice Patro?
Page 64. That is in fact a report which was published. Space 60.
We have not submitted it in appeal, but for your lordship's reference, I am submitting this for your lordship's.
No, 64 is an order passed in a contempt. Where is the report? The report is at page 66. Anyhow, yes.
It is what?
That report.
Lordship has gone through that report as well as the order passed by the single judge. The order passed by the single judge in execution petition, it refers to the statutory.
Can he do it without recording any reasons? An arbitrator who was entrusted to determine the market value, he has taken into account the several documentary evidences. Exemplars were of a land in a locality or a nearby localities. Then he has approached the sub-registrars also to have the price prevalent at the marketplace. And then he has arrived at the conclusion that it is a 14 crores. What is the flaw? Supreme Court has said that you are entitled to identify or place the flaws in the.
My lord, that was passed by the arbitrator was in 2014. The prosecution petition, that is in 2017. And that order passed by the Honorable Single Judge has taken note of the order passed by the arbitrator. So Lordship may kindly have a glance to page 160. The Lordship may.
What?
Lordship may kindly have a glance to page 161. That an additional government advocate of the state submits that the valuation arrived at by the learned arbitrator has never been acted upon or accepted by the state. It is submitted that the benchmark valuation of the petitioner's land bearing plot number 353 is rupees 7 crores per acre, as was prevalent on 9/1/2013, which is just fair and proper method to determine the valuation of the land in question. The state is ready and willing to deposit the value of the petitioner's land measuring acre 1.837 decimals in Mauja Jaidev, Bihar at the said rate of 7 crore per acre. It is submitted that pursuant to the interim order of this court, state has already deposited an amount of rupees 10 crore in the registry of this court pursuant to the interim order of this court dated 21/3 to number 43.
Sir, this is what the impugned order is.
Yes. Now,
I tell you, Mr. Das, we would have very safely proceed to dismiss your appeal on the ground of your admission or a consent. But the situation has taken, I would say, a diametrically opposite thing. Interestingly, everything has been entrusted upon the division magistrate. He did not challenge that particular the order by filing an appeal. He straight away went there and filed a special deputation. The orders are passed, and ultimately this order says that the division bench will decide whether the 14 crores is a correct or a 7 crores is a correct. So he also has to justify that 14 crores is correct. And you are, without filing any cross objection in this appeal, he is assailing the order also. Permitted to argue.
He has not filed.
I'm saying, but this order says that they can. So we have to decide whether there is any flaw in the report. 14 crore is correct or a 7 crore is correct or in between.
Here only I can say, my lord, the honorable single judge has taken note of. The order
Nothing.
has taken note of the.
Only your submission.
No, my lord. Considering the submissions, that is why that may be a very small paragraph, but it reads, considering submission, this court is of the view that benchmark valuation of the land at Jayadevia in Bhubaneswar fixed under Odisha Stamp Amendment Rules 2001 appears to be most fair and proper method of determining the
How?
market value of
How?
the petitioner's
How?
land in question. Accordingly, while accepting the market value of the petitioner's land as ₹7 crore, the state is there.
How? There's no consideration at all. He has to say that this arbitrator's determination is flawed. He has to say, simply jump. There are options. One is adopted by an arbitrator and thereafter the executing court. Just imagine, he is an executing court. He found that the other possible views should be adopted. Can he substitute this? The arbitrator has taken note of the various sale deeds. He has taken note of those, the circle rate or from the sub judge, and then arrived at the. And he said, no. The circle rate is the best way or a best method of ascertaining the market value, so I adopt it. Can he do so? Probably the circle rate is for the purpose of a stamp duty, nothing more than that. It may not. There are up to number of judgments which says so. Can't be the safe. Even a state argues differently. No, circle rate is not a correct way of determining the market value. What to do, sir? He has not done anything. I say we could have safely reverted the matter, but we have to determine now.
If the balance amount is required to be deposited by the state,
that Supreme Court will take care of that, whether you have deposited or not deposited.
Lordship may give the final hearing of the matter. But in the month of November,
No, sir.
come back and
last line.
Well, last line I have gone through and heard the matter.
Para 2.
I have gone through that.
Para 2.
I have read that line.
Para 2.
That no adjournment will be granted.
No. Para 2.
Commence the.
Para 2, my lord. To para 2, my lord. Of that.
Para 2, what will
Para 2, I can only say that the Honorable Apex Court has said that in this regard, the High Court need not.
No, this is paragraph 3.
No, para 2, post the matter to 31K.
And now you said in the November. That's why my brother invited your attention. You wanted to be posted in November.
Para 2, my lord.
What would be the answer?
Yes, my lord. Para 2, so far as the answer of state is concerned, but that instruction which I produced,
not here.
It has to be produced before them. That I
go there. Your answer would be there.
We'll produce that, my lord. We'll produce that and we will
But
undertake.
the moment it says commence an hearing, we are commencing an hearing. We are not granting any adjournment. Please, not good.
Para 3, the order the Honorable Court has directed commence the of the order. The Honorable Apex Court had directed no adjournment should be granted. But today, your Lordship have already commenced the hearing and have heard the matter substantially to some extent. all that I'm praying, my lord, if date for further hearing may be fixed. I'm not.
It's a
seeking for
sarcastic
adjournment.
smile that has come in his face. Meet him. He's interpreting the judgment like a statute. What you say?
He's saying that the
Huh?
hearing has been commenced today, as per the order of Honorable Apex Court. Next should be adjourned. If it is the time is there to conclude the argument, I am ready.
Meet.
Because they are not allowing us the interim application that we have prayed for to be released under your lordship say prerogative. As your lordship told that let the matter be finalized.
I was under the view that it can be finalized so that no problem.
They made vehement objection as regard to the release of the amount. The discussion was
So the amount to be released, how much?
Some amount to be released, my lord. If they
How
are
much?
ready to release 10 crores, let them release some amount because I am in need of money.
How much?
As your lordship pleases, because the discussion is with your lordship to Apex Court's direction, you can impose any condition. If that is suitable to us, we will receive it or we will not receive it. We have borrowed so much of money. The three brothers, one brother is now bedridden. First brother's wife is expired when the money was very much required for transplantation of the kidney. She could not, they could not release the amount. In 2016, she was under this, there is there. They did not allow us that money. Then the first, this petitioner, number 3's wife and his Mrs., they also expired out of cancer. The second brother, he is now bedridden, he is also suffering from this serious. So the money they have not given at the time of need. And in this case, your lordship, you know, the Supreme Court advocates, the senior advocate, how much fees they are taking every debt, 14 lakh, 15 lakhs rupees they are taking on check. Unless and until if the case will not be properly dealt there, then it is very difficult. The petitioner has borrowed so much of money to manage his case. And they are not realizing this thing. Where the government is spending money from their exchequer. This man is a retired government servant. It is true that he was having some paternal property, which was given. My lord, you will be astonished that for the development of Bhubaneswar city, he has contributed more than 5 acres land. Free of cost, they took the land of the petitioner for the construction of Reserve Bank quarter. They did not give that. Free of cost. So many, they have whatever they have land they have taken, they have as the compensation. This land is supposed you would have got this under the Land Acquisition Act. Now you will get 46 crores per acre now because this land's cost is benchmark valuation is 23 crores. I have submitted the
land was given by virtue of a gift deed. Land was given by virtue of the gift deed. I'm not on that.
This point is over.
That point is over.
When the writ petition has all been decided, and now the Supreme Court says either alternative, if not, then the market, if you cannot reopen that issue, it is now closed.
That is not reopened.
Now, again, an alternative land is also closed when the arbitrator is appointed by the court. So once the arbitrator is appointed, the money has to be given to them. Now the question is 7 crore or a 14 crore. That's the entire fight is in between these two figures. We'll have to argue.
So far as the IA application, my learned friend is referring to, that purely that if your lordship will look at the order passed.
He cannot believe that because the Supreme Court has said that the market price as on the date of the order, which is 9/1/2013.
But that
what is the price today is a different scenario. We cannot go into that aspect. Once the market price is determined as on 9/1/2013, he is entitled to that amount. Plus, we have to consider the other aspect according to the land acquisition. If we think those...
That is so far as the merit of the case is concerned.
Chief Justice has given an order that in the case of Karnataka,
giving last 25 years compensation. So they told, since you have not given the money, you pay the benchmark, the value of the land as per the today's benchmark value. So we have not received that amount till 33 years. Now it has become 33 years. 1992 and giving the land, now it is 2045.
But with respect to the merit.
12 years.
Now, his IA application, the observation by the Supreme Court was that the appellant shall be at liberty to move an application before the High Court in pending intra-court appeal for release of some amount of the deposited amount in their favor immediately, of terms and conditions as may be imposed by this honorable court. But the Supreme Court never said the merits of the application which has been filed before this honorable court in the shape of IA should not be considered. If your lordship will look at that IA application for medical expenses, an amount of rupees 10 crore has been
No
paid
medical
for.
expense I have indicated.
Yes, if your lordship, we have filed an objection to that IA. That is pending. And
Only thing is, let us go in that way. You cannot, not probably, but with certainty say that he is not entitled to a single penny. Cannot.
But that I cannot say now.
That's why I'm saying you cannot with certainty say that
I
he is
cannot
not
say he is
entitled
not
to
entitled for any.
any penny.
Yes.
He is entitled. Now, what should be the amount
Yes.
is only the question. Because the property has a value. You cannot say that it does not have a value.
It has a value.
Now, what should be the value? So, if by all means the property which is there will not fetch less than 7, you also admit it. Then why not the amount apropos the same should be allowed to be given? Or at least the half of it to be on a very conservative side.
As an interim measure.
Definitely.
So, but as an interim measure, his application, the merits of his application was also to be looked into.
Sir, after all, just imagine this is the money, I wanted some money for my use. What I will do is my job, is my money. The court may say, yes, definitely you have some, you are entitled to some portion of the money, may not be in its entirety. Will not court permit him to withdraw or take it? If by all conservative way, the property price is not less than 3.5 crore. If it is not, by all probability, why not he should be released 3.5 crore immediately? That is what I'm saying. 7 you are disputing, I understand. He claims 14 disputed. But in between 3 crore or 3.5 crore is the most reasonable.
What's it done?
10 was there. Just to show a bonus. And the Supreme Court has said the deposited amount, whatever, some amount. So,
Direction.
Huh?
Yourself for the interim period. So just to repay the borrowings.
what about the hearing?
Hearing Mahila release some amount, it takes some 1 week time. After that, as they are saying, because they are requesting honorable court. But some amount.
Yes, pay. Where is the money deposited?
10 crores already deposited in the registry of this honorable court.
So from there he will be entitled to get back.
Balance part, we will deposit in the meantime, because today's instruction also I have produced before the honorable court that 15 crores.
Yes.
Deposit.
Which order the 10 crore is deposited? Where is the order? Can you give me a date? Be the date of
Date-
the
date,
order
29/4/2016. 29th April 2016.
My notice is 29th. No, in the meantime, the sanction has already been done. Right?
Instead of 28 on first week of the site selection is not raised. Site selection.
Item number 20. Item number 29.
No. 29 can it be? Because it's a small matter. It's a small but very small matter, my lord. The signatures. I have a very difficult experience, I have a very weird experience of the small matter. If my lord will permit me, we have seen the Supreme.
Statement for state of Haryana because we wish to. That's what we are saying. That's the reason we want to fight it.
And those
So I'm saying, your lordship.
Recruitment of the guards in MCL, we have succeeded before the honorable single judge. Illegality has been virtually admitted by the other side.
Come on 27th, you know.
2 p.m.
2 p.m. Because 3 p.m. is come on 27th and
2 p.m.
2 p.m. Yes.
27th.
Yes. I understand these are the problems because Mr. Natarajan has shown a lot of things and he fairly concedes some and
From their concession, I will start with.
yes.
Take 5 minutes for me only.
Okay.
I don't know.
Anyhow. What?
Item 53. Next.
It will fall.
Despite of this annual report, they are constructing the building.
Come to